Hi guys, my name is Diana Romanovska and I am a certified family law specialist practicing family law in San Francisco and the Bay Area, California. Today I would like to talk about domestic violence restraining orders in California. I have probably the most high season for domestic violence restraining orders in my entire career, 2022, close to winter time. So we're in November. Now, what is restraining order? So if you go on Google and I type in DV-100, it's called Request for Domestic Violence Restraining Order form. Number one, person asking for protection. So you type your name, your contact information, person you want protection for, your relationship. And domestic violence restraining order can be only between, and there is a list of people on that form in number 3 who can file it. It cannot be a neighbor. So it has to be married, registered domestic partner, or used to be married or being domestic partners, dating or used to date. You see, the theme is it has to be personal relationship, more like parent, child, grandparent, brother, sister, sibling. So that's where you can see the list. Now, to answer the question I asked, is on page 3. I mean, it's not physical anymore. So it's harassed, made repeated unwanted contact with you, tracked, controlled, or blocked your movements, kept you from getting food or basic needs, isolated you from friends, family, and other support, made threats based on actual or suspected immigration status. If someone says, well, if you don't do X, I will divorce you and you will be deported, something like that. Made you do something by force, threat, or intimidation. Stop you from accessing or earning money. Hit, kicked, pushed. Here's the physical. But did you notice how much is non-physical? And it becomes very common for people to use text messages. So whatever you're texting each other can be used against you in court, or vice versa. Whoever receives the text can use the text against the abuser. Sexually abused you, threatened to hurt or kill you, injured you, or tried to, abused a pet or animal, destroyed your property, choked or strangled you, abused your children. So in some cases, there is no evidence. Let's say someone is very careful, a person who abuses another person, and they know not to keep records, they know not to do it in private. Let's say in the bedroom where there are no cameras. People sometimes have cameras in the main room or outside, and then they know there is no camera, so they can do whatever they want and say things, threatening things to the other person. Now, if you expect that someone is going to abuse you, this is the only exception. You're not allowed to record, voice record, video record the abuser without their consent, or another person when it's in private. So if it's in public, in a store, that's fine. Outside, on the street, there is no expectation of privacy. However, in your own bedroom, there is an expectation of privacy. If you record that person, it's a misdemeanor. The main thing is secretly record that person. And that is an exception to a penal code section where it's not misdemeanor when things like that happen. So I had a case where a wife recorded secretly and used that recording against husband in court, and that evidence is permissible. So that's how potentially you can overcome he said, she said if you have hard proof. So the process of filing a domestic violence restraining order includes filling out a bunch of forms. It's DV 100, DV 110, and I will create another video. If I don't remember if I have a video about all the forms. It's very specific, but you can also Google it, self-help, how to fill out, or find a clinic. In California, there are free clinics who help out to fill out the forms, draft up the declarations. Clinics for people suffering domestic abuse, there are shelters. So that's a separate topic. And once you fill out these forms, you submit them to the court, 2 copies, and in 24 hours receive a hearing date, and then you need to serve that 1 copy to the abuser by hiring a sheriff, because domestic violence is not effective or valid against the abuser until the abuser sees the forms. So he or she needs to be served. So sheriff or private personal server. The difference between sheriff and private personal server is sheriff is less expensive, slower potentially, and more intimidating. Private server is going to be more, you give them the assignment to serve right now, they will do it. Sheriff has other things to do, they might do it in a couple weeks. So that's the difference. Now, so you have that restraining order. What does it provide? What advantage does it provide? And what disadvantage also domestic violence restraining order has if it's filed based on false accusations. So the advantage is that the other person has to stay away. So if a victim is truly, honestly is afraid of the abuser, they have to stay away. Now, we have seen all these Netflix probably series where a piece of paper is not going to help an abuser to come and do what they want to do. However, it gives it gives more, I guess, a feeling of safety, because if you notice that the abuser is about to, enter your house, you can call the police and say, even if they don't do anything yet, meaning they just come close to you in violation of the restraining order, they can be arrested for violation of the restraining order. So that's number one benefit of having a restraining order. Custody-related benefits. And I don't know if the word benefit is really the right word, because it's not about, positive and negative or benefit and disadvantages, but I would say, what does a restraining order provide? It provides a presumption, a 3044 presumption for the victim that their child is also protected, if child was a protected party to the restraining order. And even if not, it's still considered, the other side is considered an abuser, and the presumption 3044 is a code section, family code section, where the abuser will have to come back in a year, 1 year, based on the case law, and show that he or she did 52 weeks of better intervention program if that was ordered. If not, whatever was ordered, basically come back and say, why am I allowed to be back on a legal custody? As a reminder, legal custody is who can make decisions about the child. If there is a restraining order in place, the protected party will have sole decision-making, sole legal and physical custody. The abuser will still get visitation depending on the level of abuse, supervised or unsupervised. However, we have two different topics, custody and visitation. So now in custody, let's say the abuser comes back in a year and tries to rebut it, they will have to show all these factors. The court has to make a determination about whether or not it's sufficient. So it's not automatically. It's going to be done through judicial process, through a hearing. And for example, in San Mateo County, in San Mateo and Alameda County, it's a recommending county, meaning both parties will be sent to mediation, and mediator will make a binding recommendation that court typically adapts, sometimes with minor changes, whenever someone is filing custody modification, which would be from sole to joint. So that's what restraining order provides as number 2. Number 3, if the restraining order is on such a high level that, there are 3 different code sections about spousal support on whether the abuser was convicted, or whether it's misdemeanor, and whether it was domestic violence restraining order. So depending on the level of severity of the restraining order, the victim of domestic abuse shouldn't be required to pay the abuser spousal support. And the court still, after deciding that restraining order was granted, still has to make a determination it's enough for spousal support to be paid or not. So it's not a clear cut about, once you get domestic violence, as a victim, you don't have to pay spousal support. So that's not the case. All right, so those are things that domestic violence restraining order provides. On the flip side, if the court determines that the victim of domestic violence has not been truthful or credible, it's not always a clean cut. Sometimes people perceive abuse when there is none. For example, I had a case where a victim claimed that the other side would not provide them financial assistance, yet that victim was traveling 5 times a year, sometimes 1 month at a time, to different countries at the community property money expense, leaving the alleged abuser with a 2-year-old child, while the alleged abuser was making all the money, basically. So it was such a disconnect from perception and the reasonableness that the court determined that on this factor, it's not credible. And then we went to another factor, and another factor. It was a 6-day trial where the victim just created these perceptions of the events as abuse in order to get advantage in custody matters. And there was this dynamic of, I'm a better parent, I want more attention from our child. It was more competition. So sometimes people use domestic violence as a power tool to have more custody, more time with their child or children. Not always. It's not always black and white. So before making a decision to file domestic violence restraining order, I would consult a lawyer and say, look, or a therapist ideally, and describe it and have a soundboard and walk through mentally the steps that I'm describing and make sure you're ready for this. Because if someone is found to be not credible and the other side is fighting 6 days to prove they're innocent, it's not like in criminal law where the prosecution has to prove beyond reasonable doubt that the perpetrator is a criminal. Here in domestic violence, the alleged abuser has to put evidence forward to discredit the victim if the victim is making false accusation of domestic violence. And then there is this code section that says prevailing parties attorney's fees, meaning if abuser prevails and the court finds the victim not credible, then abuser is entitled to get alleged abuser, who is then found to be not abuser, will get prevailing party attorney's fees. So I think I covered all the topics on domestic violence. Some people like to tag more things to domestic violence. For example, child support. There are boxes. If you scroll down the form DV-100, You can add other protected people, like your parents if you live together with them. Then the alleged abuser will have to surrender the guns and file a form DV-800. So then you check off number 12, the stay away order. And there are other orders like spousal support, attorney's fees, protected animals, control property. For example, if you would like the abuser to move out but still pay for the mortgage, that's where you have to describe in the form that how much and when is it due. If you would like him or her to pay for health insurance, if you would like to be allowed to record communications at any time, that's number 19. And if you would like to pay, have them pay other debts, number 22, including mortgage, telephone bills, garbage, whatever that is. Because typically once you occupy the property, you're solely responsible for the carrying cost of that real property, whether it's rent or it's mortgage. And by filing in domestic, some people are afraid to file because they cannot afford to pay for that particular place they're planning to stay with their child. And that's when they can ask, instead of going to shelter, they can ask the abuser to move out and pay for the expenses. And then attorney's fees, spousal support 25, 26, 27, ask the court to order that the abuser undergoes better intervention program. And that's it. Attorney's fees. I think some of you might wonder, how much does domestic violence restraining order cost if you hire a lawyer? And we're in 2022. So currently my hourly rate is $5.25. The retainer for domestic violence is $5,000. And it depends on the complexity of the case. If I, for example, right now, when I take a domestic violence restraining order case and I interview the client and I believe what they're saying, after asking them many, many questions, I don't straightforward like to go and defend them, whether in pursuing the domestic violence or defending domestic violence, without deposing the other side. The reason for that is I only get to see one side of the story. And as much as I believe my client, I need to get to the bottom of it and see it also from a bird perspective, from a judge's perspective, from outside looking in. And the only way I can do it if I depose the other side, if I see how they think, what they believe in. For example, in that story about accusing my client of financial abuse, in the deposition I found out about all these, well, my client told me about all these vacations, but I also had to know whether that other side is going to admit that they went and how they spent that money and what in their perspective was lack of financial help or lack, or where were they cut off of financial sources. So it's important to find out a couple of things. The fact finding, so I would know if my client is telling me the truth based on listening to the other side and see how, listening to my gut too. Second, find out how credible they would be if they were to testify. So assess the matter if it makes sense to go to trial or not, or if I have to manage my client and tell them, look, if we go, I don't know how to believe you or not, but perhaps there is some disconnect and the court might find you not credible. That happens too sometimes, that clients believe in one version of the story, but there is this other side. It just gets a little tricky. And so that's where the costs come in. So $5,000 the retainer to fill out the forms, the declarations. Doing the deposition is another set of costs, which can be 10, 20 hours depending, preparation, the actual deposition, and getting the transcript and paying the reporter and then preparing for trial. Preparing trial brief can be another 5 to 10 hours. Going to court, depending on how many days, it could be 1 day, 2 days, it could be 6 days. So you get the gist. It can be very, very, very expensive. However, it doesn't mean that if you're a victim of domestic violence that it should shy you away, because the facts are what will speak in your case. And that's where, if money is a problem, to get clinic, to get help, to get even as the court, if there are children and child involved and domestic abuse happen against the child, to ask for emergency screening. For example, in Santa Clara, the court will order the abuser to pay for a psychologist to do an emergency screening, where a psychologist will go to different people, including the abuser, the victim, the child, the school, the parents, friends, and then create a report and state an opinion, what custody orders they believe should be in place. And other counties have that too, and so that's another, it's called emergency screening, where it's all can be delegated to the system to help uncover the truth. I think now I should have finished everything I had in my mind about domestic violence restraining orders. I hope that was helpful. If you have any questions, comment down below, and I'll see you in my next consultation. If you like the video, please like, subscribe, and see you soon. Bye.